Well,
All right, welcome back. We are live now, and we're going to be talking about H-132, which is the an act relating to establishing a homeless bill of rights and prohibiting discrimination against persons without homes. And we've let Julio know. Does he have a time? Does he have a time ceiling? Okay, so we can start. Can we start with Boar then? Okay. Boar, we're gonna. Hi, Boar. Boar, we're gonna. This is not a new bill to this committee or to you, but it is to many of the people on the committee. And we are strongly considering putting this language of H-132 into S-100. We find the timing of this is even more prescient than it was 4 years ago. And we just wanted to get your thoughts on this, and perhaps it'll be, again, look for your notes from 2020 or 2019, but I would first start by introducing us to you because we are so new to you. There's probably only three of us here who were on the committee last year. So Representative Tom Stevens from the Washington-Chittenden District.
Hi, Boar. Saudia Lamont, Morristown, Elmore, Worcester, Woodbury, and the northern part of Stowe.
Joe Parsons, Newbury, Topsom, and Groton.
Emily Krasno, South Burlington.
Ashley Bartley, Fairfax, and Georgia.
Caleb Elder, Starksboro.
Dennis Labonte, Linden, Newark, Sutton, Sheffield, Wheelock.
Hi, I'm Elizabeth Burrows, and I represent Heartland, West Windsor, and Windsor.
Hi, Boar. Representative Mary Howard from Rutland City District 6.
And Robin Chestnut Tangerman, Rutland Bennington District.
So, Boar, there's two distinct sections to the bill. We had a walkthrough last week. And basically, we know that the bill has a series of what we would consider, well, we're hoping to find a better phrase than a homeless bill of rights. I'm not sure if it's homelessness bill of rights or what have you, but that language seems a little awkward now than it was several years ago. But also the notion of where someone's housing status would also be included in all of our discrimination sections. So if you could just give us a quick introduction, because this is the first time you've been here this year, and just of what the Human Rights Commission does and what your interest might be in this bill.
Yeah. Well, thank you so much for inviting me, and I'm so glad to be back, and so nice to see all of you, some of you again, and some of you for the first time. My name is Boar, and I am the Executive Director of the Vermont Human Rights Commission. And for those of you in the room who don't know what the Human Rights Commission is or does, is we enforce the anti-discrimination laws in this state in three areas: housing, places of public accommodations, and state government employment. So while this bill, I just want to sort of clarify that, housing discrimination is landlord discrimination, but also tenant-on-tenant harassment. It also covers rental managers as well as real estate agents and zoning boards as well. Places of public accommodations in the state of Vermont has a very broad definition, and it includes schools, it includes government entities, as well as businesses, hospitals. And while we have jurisdiction to oversee the Fair Employment Practices Act in regards to state government employees, it is the Attorney General's office that has jurisdiction over employees of municipalities and private employers. And so but HRC is the only place that oversees the anti-discrimination laws in housing and in places of public accommodations. And as Chair Stevens has mentioned, and as you all know, H132 seeks to amend the laws that we have jurisdiction over by adding housing status as a protected class of people. And for the purposes of my testimony, I will continue to use the term homelessness, but you're right, there is ongoing conversation about that term and what it means. But we know that homelessness or houselessness is a serious human rights issue. And there's very little accountability under our existing laws. We know that studies have shown that being homeless impairs health, can even cause premature and preventable deaths. It's associated with aggressive policies that really are punitive rather than protective of the rights of people who are homeless. And we know that people who are homeless have been denied housing, the right to work or vote because of their lack of official address. My understanding, there's only a few states that have passed laws to protect the homeless. Rhode Island, I think, Illinois, Connecticut. Other states such as California and Colorado have also considered similar bills. My testimony today is very brief because I really want to save time for questions. I mean, we see this as a human rights issue and the commission certainly supports this bill and thanks all of you for taking it up. And I'm happy to answer any questions that you may have on it.
On discrimination, while we have a lot of protected classes, what we call protected classes, I mean, it just seems to be like, as we identify more people in different ways, beyond what the federal government does. I mean, it's always struck me. I remember one of your predecessors said, well, we still allow discrimination. It's just a question of how do you identify it? And in the case of, let's just use the unhoused or people who are experiencing homelessness, you know, some of the testimony we've taken in the past is, well, does this mean that no one can, that people who are experiencing homelessness can just hang out in front of my store? And the answer would be, if you single that type of person out, yes, it's discrimination. If no one can stand in front of your door, then there's no specific discrimination that's going on. It is, I mean, which is a cultural way of trying to be inclusive, to say that people who are experiencing homelessness shouldn't be treated differently, in this case, a negative way. Is that, I mean, we still, that to me was always the biggest question about how does one determine what homelessness or perceived homelessness might be, and how would it come to you if someone decided to press a case or to ask what their options are?
Yeah. So I'm just going to backtrack a little bit and talk a little bit about what is like discrimination and how do you prove it? And there's different forms of it. There's discrimination. Discrimination can be harassment, which is creating any kind of hostile environment that makes it difficult for someone to engage in at work or to shop or to live and enjoy their dwelling. Discrimination can be unintentional, such as an Equal Pay Act. And we have a form of unintentional discrimination called disparate impact, which is when there's a neutral policy that has a disproportionate impact on a group of people. And that can also be a form of discrimination. Usually to prove an unintentional discrimination claim, you have to have statistical analysis. And discrimination often is what we all know it to be as intentional discrimination, meaning that the person that engages in the behavior intended to discriminate against a class of people. So if a business, let's say that runs a store, is allowing people to shop freely, but sees that an individual maybe looks unkempt and believes them to be houseless, and asks them to leave, but doesn't ask anybody else to leave, that could be a form of intentional discrimination because you're targeting that specific individual. Can a business set like normal rules around how many people can be in that store at any given time? Sure, absolutely. Because that doesn't really impact, that really isn't intentional. It doesn't target any particular group. Can a business say we're going to close at 5 o'clock and we don't want anybody in the store at that point? Sure, absolutely. Those are regular rules that a business can set. So when you're looking at intentional discrimination, we're looking to see if someone was targeted specifically. Now, how do you prove that someone is targeted specifically? Well, a lot of times we look to see if any statements were made. For example, let's say a store owner says, look, I don't want your kind around here. You're going to have to leave, okay? And I don't believe that you're really here to shop. Or those are comments that kind of suggest that we're making stereotypes about this individual. A lot of times we don't have statements like that. What we do have is a comparison. We have the fact that you have a store owner that might tell someone you have to leave, but tell other people you don't, and allows them to stay. And you're comparing what the difference is between the two individuals that are asked to leave or permitted to stay. And we call that sort of comparative analysis to prove discrimination. So that's how we would kind of look at it if someone filed a claim of discrimination on the basis of housing status. In the same way we would look at it in terms of race or national origin or sex discrimination.
Right, and in this case, in the case of discrimination cases that come forward to you, I don't want to downplay any kind of litigation or possible litigation, but truth of the matter is what? When something like this comes to you, you need to make those determinations before you can bring litigation. Is that right? I mean, just
Yeah.
You have to review the case as if it were any legal case and decide whether or not even so much if it has merits, but if it could win on its merits. Is that accurate?
Yep, it is. So when, let's say someone calls us and says, I'm being discriminated against, the first thing we would look to see is, one, does this fall within our jurisdiction? Is this a housing provider? Is this a place of public accommodations? Is this a state agency or department? Two, is this a member of a protected class? Right? So that's almost always the second question that we're asking. And if they said, I'm being discriminated against because this person assumed I was homeless when I applied for this job, immediately this would not fall within our jurisdiction because currently housing status is a protected class. So you adding this to our statutes allows that second inquiry to get in the door. Right. And then we would ask what happened and does it appear to violate? If it's true, we don't yet investigate whether it's true or not, but if it's true, does it appear to violate the laws? And if the answer is yes, then we open an investigation. The bar is low to get in the door. We open an investigation, and then the bar to find discrimination is reasonable grounds at the Human Rights Commission. That means, are there reasonable grounds to believe that discrimination occurred, that the law was violated? Then if we find that the commissioners determined that there are reasonable grounds, we still try to resolve it for 6 months before we file a lawsuit in court. So it's a very lengthy process. In all of that time, we're working really hard to help the parties reach a resolution. That resolution is education many times. That resolution can include sometimes monetary damages, but it's education, it's training, it's a commitment to changing policies and protocols, putting up those policies and posting them in places where other individuals can see those policies as well. And so, there are many opportunities to sort of reach a resolution even before we make a final determination that discrimination has occurred, and even after.
Thank you for that, because that's there's a stereotype that, or an assumption that adding a protected class or having a group of people who are in protected classes is an excuse for litigation, and that's not what you just said. That you're trying to find a resolution that avoids litigation.
100%. We're always looking for that. Litigation is uncertain, it's expensive, and it's time consuming. And litigation is a form of last resort. I also we don't get a lot of calls around houselessness as we don't get a lot of calls from people who are claiming discrimination on the basis of housing status. But that isn't to say that if you pass this bill, we wouldn't. I think part of it would be educating people that we are now adding this. In 2018, we added victims of domestic violence to the list of protected classes under housing, and that we did get cases in the door because of that. And that was great that the legislature supported that. And I do think that this bill has the potential to bring in some cases in the door that have fallen through the cracks or that right now exist in the gaps in the law. There have been some recent conversations in Vermont around people who receive public assistance who are being housed in hotels and motels, and whether they fall through the gaps, and whether they can file claims under the existing anti-discrimination laws. I think potentially this law could open the door for some of those people to have their grievances addressed. But having your grievances addressed, like you said, Chair Stevens, is not a path to litigation. That path is long and again expensive and not an easy path for people to take.
Thank you, Laura. If I can step back a bit, the original anti-discrimination law seemed to me, and I'm looking for you to guide me or correct me here, needed. Original anti-discrimination law seemed to be about something about a person that is immutable, race, ethnic history, gender, and it seems like this is adding something that is hopefully a temporary condition, not a personal choice, but usually not a personal choice. And I'm just wondering, is there a legal distinction there that we should be aware of between something that is a basic fact of a person's life versus a temporary condition?
Yeah, that's a really great question. I would say, at one point, disability under the law had to be relatively permanent. And since some amendments to the Americans with Disabilities Act, the courts have sort of opened the door to disabilities that are less than permanent. Also, age is a protected class, and certainly people are in different age groups from time to time. I don't think that the distinction should be, whether or not you support this bill should not necessarily be based on the distinction of whether the trait is permanent or not. My feeling is are these groups of people who are vulnerable, who face discrimination, and do they need protection? Are the questions that I would ask. And here's the thing is, even if someone could get out of being homeless in the future, doesn't mean that they aren't particularly vulnerable or in need of protection during the time in which they are homeless. And so the more important question is this a group of people that have been marginalized in history? Are they vulnerable? Do they face discrimination? And are they in need of protection? And I think the answer to all of those questions is yes.
Thank you.
Yeah.
Further questions for Bor right now? And Bor, we're going to have you back on S100 sometime this week as well. There's a section that affects the Human Rights Commission in S100. It's two sections. All right, any further questions for Board right now on the H-132?
Yeah.
I appreciate the clarifications on this and, you know, it's interesting because while there is plenty of litigation that can be had, one would think, I go back to the fact that the goal is to just let people know who are operating in the the space of public accommodations, whether it's housing or just retail, wherever our community is that the expectation is that everyone should get treated the same. And that's, I think, what this bill is about. It continues the story of making sure that there's people everyone is treated the same. Representative Lamont,
Yeah, I just had a question, I just formulated a question for me. Do you think that, just, and this is an opinion, I suppose, do you feel that having, designate this as a protected class and having this would alleviate some of the calls that you get, and would it help better serve your office to have this included as protected class? Or do you see any barriers or hindrances to this?
Yeah, that's a great question. I don't think that adding this is going to have a significant impact on our office and the work that we do. I do think that you're closing a gap in the law, and it will have a significant impact for some of the people who we have turned away. It's not a significant number. And if it were a significant number, I would be in here asking, and I knew that, I would be coming in here asking for a staff to support that, because we are consistently understaffed at the Human Rights Commission. I don't see that being a concern here. If we were talking about another protected class like bullying, absolutely. It would be opening the floodgates to a lot more cases in the door. And that's also an area in our law that has a gap too. But we'll talk about that on another day, maybe under another bill. But yes, I don't see it having a significant impact. We have a lot of protected classes, and many of those cases don't show up at the Human Rights Commission. Like marital status, I think we've had one case in the last 8 years that I've been at the Human Rights Commission where we've had a marital status discrimination case. We rarely get HIV as a complaint. We get age discrimination from time to time, but it's not frequent. In fact, the most frequent types of cases that we get is race and disability, national origin sometimes, and certainly sex discrimination. There are just groups of people in our society who face discrimination at more prevalent rates than other groups. And that's just always going to be the case. I don't think that means that we don't create a path for other marginalized communities. And I certainly see this bill as addressing that. So.
Excellent. Thank you.
Yeah, thank you.
all right, thank you, Board.
Thank
Good
you
to
all
see
so
you.
much.
Happy
I'm sorry
New
I
Year.
can't. Oh, go ahead.
I was gonna say Happy New Year. Haven't seen you.
I'm sorry I can't stay to answer any additional questions in case, I don't know if Julio's testimony might bring it up, but as I said, I'll be back, and feel free to shoot me an email if other questions come up. Thank you so much for your time and for giving the attention this bill deserves.
Great, thank you. All right, Julio, welcome back. I'd like to say we're all teed up where you left off, but I'm sure you are. So we're still on H-132, and you were taking us through some of the considerations that we talked about a little bit differently with Board than with you. But welcome back, and if you can jump right in.
Okay, sure.
I think we've identified, I think your last testimony identified areas where we might have to just review some of the language, the specific language, but just in general.
Sure. So I'll introduce myself for everyone tuning in. And for those of you who may have forgotten. I'm Julio Thompson. I'm an Assistant Attorney General, Director of the Civil Rights Unit. I'm here really to talk about the employment portion of H-132, since that's the only portion that we would have enforcement unless there were a housing case that involved criminal conduct. There's actually a provision under the housing law that would involve criminal actions which the Attorney General, along with state's attorneys, could enforce. We haven't had any of those cases, but that's theoretically available. So I'm just going to confine it to employment. And before I start getting into the remarks I want to organize, I just wanted to follow up on a point that I heard about from the representative about immutable characteristics, and the protections usually focus on that. It's a question. It's a great question. One we get a lot when we're doing trainings and stuff like that. But often people forget that one non-immutable characteristic that's been protected since the 1790s is one's religion. First Amendment was ratified in 1791, became applicable to the states when the 14th Amendment was enacted in 1868. And so people voluntarily select their religion or change their religion or choose to worship and not worship. The other non-immutable characteristic that we've protected from their very get-go is speech. Most of our speech, we think, is voluntary and something that we have a choice in. We're not born with political viewpoints or viewpoints about public policy and the like. And so we've had constitutional protection of two major areas of of changeable characteristics that are up to all of us from the very beginning. Other areas of law that we protect that are not immutable, we have different protections for professions. So there are certain criminal laws that make it a higher penalty if you assault a police officer versus, say, a real estate agent or a medical worker. And I think there's legislation pending in this building now to look at sanctions for healthcare workers. Last year, you all voted in favor of a bill that provides enhanced penalties for threats that are directed at public officials, and all those professions are choices that people make. So in terms of our work, whether it's a changeable characteristic or not, it's pretty much looking at what is the harm, and is it the harm for a particularly bad, the Constitution uses the thesaurus word invidious for a very, very bad reason. And our experience when we encounter the issue of homelessness in our work, we find that there's when we do see discrimination, there's a lot of stereotyping, and that's kind of at the heart of a lot of anti-discrimination laws. People make assumptions about people because of who they are, the way they look, and so forth. And that's true with homelessness as well. I think that, for example, when you have a conversation with your most sympathetic and educated friends, a lot of them, when you ask what they think about when they think about homelessness, they think about people who are sleeping on park benches and who might have mental illness or substance use disorder. But from our experience, and this is really a product of widening the lens in anti-discrimination law to cover crime victims, some of the people that we encounter who are facing the crisis of homelessness are victims of domestic violence. They are people who fled their house. They are doing the most rational thing they can possibly do, which is to escape danger. And those individuals are not necessarily on park benches, not necessarily at shelters, because in some cases they're not safe at shelters. We just had a homicide in the shelter in the state this week. But they're sleeping, like they're couch surfing, as folks call it. They are staying with relatives, but they don't have a permanent residence. So we capture some of those cases through crime victims. But oftentimes we don't think we capture all of them, because especially people who are fleeing violence in their household, they and their children are trying to be invisible. So filing with the Attorney General's office and going to court is the last thing that those people want to do. So in terms of the litigation, I heard a little bit about it when I walked in. Because of the stigma, the cost, and the visibility, court proceedings are public records. And they may be trying to flee someone. We think litigation is not a highly likely avenue for this. When we do our investigations, and perhaps the board covered this about their investigations, by law, by state law, they're confidential. So the respondent employer is notified. We send them a letter, welcome to the investigation. Here are the allegations we received. Can you respond to them? And if you have an attorney or HR professional, whoever is going to represent you, have them contact us. And we also offer the mediation, just as Bor, I'm sure, mentioned. So we tried, like the Human Rights Commission, to resolve those cases. They're not in the newspaper. If there's a settlement and someone gets the job or has an opportunity, sometimes they just want a job interview. That's all they want, is the job interview, just a chance to compete. But if the employer says, well, if you have a PO box, you're not going to get an interview. And so sometimes we will try to work with them, even though we don't have homelessness as a protected category. Sometimes we can see whether there's something else going on. Like, are they making an assumption because a person's homeless that they have mental illness or substance abuse disorder, and that's why they're homeless? Or maybe they make assumptions about whether they're a crime victim. But we're sure we're not capturing everyone. With respect to disabilities, in terms of, again, this maybe closes the loop on immutable characteristics. Since 1987, Vermont has protected not only individuals with disabilities, but people who are just perceived to have a disability, even if they don't. So if someone, and the cases come all sorts of flavors, where someone in an office is raising money for a breast cancer foundation, Race for the Cure, and assumptions are made about that person that maybe they have, if not themselves, maybe they have it in their family. Or it could be association with people. So we have race discrimination cases sometimes where the target of the discrimination is a white person, who's the employee, but is married to a person of color. And that can be also unlawful. The idea being that you're defying the employer's stereotype of how white people should behave, which is that they should keep with their own. So you do have individuals who don't have, a particular, like they're not part of a marginalized population, but might be perceived as that. Similarly, our hate crime laws, for example, have enhanced penalties for a crime that's committed against somebody that's motivated by their race and their color and their national origin. But one of the protected categories is service in the armed forces. And that was born of a time where there were people who were in the armed services were subject to acts of violence or vandalism or other acts of harassment by members of the public, maybe had particular views about the U.S. military involvement at that time. So we've had that protection going back to the 1990s. When we're dealing with people who are in a housing crisis of some sort, and particularly for that population, and again, when it comes to crime victims, it's almost, in our experience, it doesn't mean that's representative of the whole world, but in our experience, it's almost always women fleeing violence, often with children. They're dealing with physical danger to themselves and also emotional trauma, which are independently barriers, any kind of interactions with anyone. So if someone has traveled whatever distance they have to travel to be ready to apply for a job, and then to face discrimination because of that, it is really problematic. Again, to add another detail relating to people in housing crisis because they're fleeing violence. The stereotype there often that we would encounter, we don't encounter many of these cases, but when we do, the stereotype thinking that we encounter is a worry that their abuser will come into the workplace and create drama. And when we hear the word drama used in association with women, we're also thinking about gender stereotypes that can come into play as well. So we find that someone being in housing crisis can touch on several other protected categories, but maybe none of them are sufficient enough for us to take action. So this makes it a little bit easier for us, would make it a little bit easier for our office to connect the dots and pursue something to see whether employers, are giving the person a fair opportunity to apply for employment or to maintain their employment. Because sometimes employees lose their housing status while they're there. And then word gets around to the employer, and then there are assumptions about why that happened. Again, stereotype thinking. It could be beliefs about disability, substance abuse. Could be that someone is a stereotype view that people who can't keep their act together, they're flaky. There are without thinking they're mentally ill. So there is a fair amount of stereotyping that can go on where you're making assumptions. When we all know, sometimes people are in housing crisis because of a medical catastrophe in their family, or it's not their finances, it's someone else's finances. Maybe they're economically dependent on an individual who has some reason. Maybe they're the one who's not stable. So we think that it does cover an area that sometimes is missed. Like Bohr and the Human Rights Commission, we don't anticipate that this would result in an avalanche of cases. We had the same question with respect to crime victim status back in 2019, and I don't know how to say it. I was going to say regrettably, but it's all regrettable. There are many more crime victims in Vermont than there are people without homes, and we just haven't seen that avalanche. There are just more people who they may not be getting to us, and that's our job to be better there. But I don't anticipate that. Could we use more people? Yeah, I could occupy 5 people right now full time, obviously, but this isn't an appropriations bill, and that isn't a condition for us wanting to do the work. In terms of, I just wanted to address a point that came up last time in testimony, because I did do some homework after I left, and there was a question from a representative here about the I-9 form, about whether the I-9 verification of lawful status for employment, which employers have to fill out, and then they don't have to file it, they just have to produce it if they're subject to audit. And I checked with U.S. Customs and Immigration Service, and in a guidance they put out in 2017, they expressly said that that applicants and employees can use their residence or a P.O. box. The employer cannot use a P.O. box for their place of business. So, and I could provide I'll upload that to the committee. It's a written guidance that came out as part of a Q&A with USCIS. So that we don't think that would be a barrier. The jurisdiction right now that we're aware of that has employment and housing status as a protective category is Washington, D.C. That's the one that we're aware of. I mentioned hate crimes briefly. I don't know if you want, I can do that at some other point in the testimony or not. I'll leave that to you, Mr. Chair.
Yeah, if you want to chime in on hate crimes right now, that would be great.
Sure.
Yeah.
When we were looking at the bill and evaluating, this is viewing at what protections may benefit this part. These Vermonters who are neighbors without homes or permanent homes. One area that we thought might be addressed would be the Vermont's hate crime law. Like I mentioned earlier, since the 1990s, Vermont's had a hate crime law. Basically, that provides, on the criminal justice side, enhanced penalties if someone is targeted for a crime, any crime, often property crime, vandalism, or it's an act of violence, that there are enhanced penalties if it was motivated by hatred of that person because what they look like, who they worship, and so forth. We've seen in Vermont cases where people are targeted for violence because they're homeless, because they're targeted, not because, and those are cases where when we examine them, it's not their race, nothing to do with, in terms of victim selection, no evidence about a perception of mental illness that we could divine. There's a fact that this was a homeless encampment, and so people come around to destroy their possessions that are available or commit acts of violence. Our most senior civil rights investigator who works on hate crimes and biases with me and my colleague, Emily Adams, she did some quick research for us after the last testimony, and we've identified, I think there's 7 states plus Washington, D.C. that include housing status in their hate crime laws. That's Florida, Maine, Maryland, Rhode Island, Utah, and Washington. This might be something that as consideration in, I don't know if it's this committee or another committee. But we're open to it. We think we could benefit from that because we have seen cases where people who are without homes have been specifically targeted. That's not to say that those cases, when they're solved, there is a criminal sanction available, but it would enhance it because the cases can exhibit a certain level of viciousness, I think, in terms of the acts. Our hate crimes laws also, existing law, allows the Attorney General's office to go in and get an injunction against someone who's committed or threatened to commit a hate crime. So if we had something, people who were targeting a particular area, an encampment is the word that people often use. If we had someone who had done that, even if that individual didn't want to pursue criminal charges, we could go to court to get an injunction to get the perpetrator to stay away from that encampment. Violation of a hate crimes injunction, which is something you get in civil court. It's a very abbreviated process. It's basically affidavits and a contested hearing in front of the judge. Violation of a hate crimes injunction is a crime in Vermont. So there's real teeth to hate crimes injunction. And so that would be something that we think is worthy of exploring as well as coverage in housing, public accommodations, and employment.
Just a very quick clarification because I'm scribbling down while I'm listening to you.
Can I talk fast?
Did you say the 7 states plus Washington, D.C. have hate crime laws or hate crime laws that protect homeless people?
Those are ones that almost all the states have hate crime laws. There are about 45 states.
Yeah. 7
of them, and this is a relatively recent development, but 7 of them have hate crime laws that include housing status.
Okay.
I'm really bored, and I work with some of those folks. And we share training sometimes in hate crimes with other AG's offices. And so I know the folks in Maine, for example, and almost invariably it comes up after there's a heinous act of violence against one individual or a group of individuals. And those times of hate crimes, I mean, it's a whole nother hearing about different types of perpetrators. They're not from organized hate groups. They're what are sometimes called reactive offenders or thrill seeker offenders who are trying to show off in front of friends, and they pick on the most vulnerable. Because the assumption is that people who are living out in the open are not too tight with the police. They're among the least likely to report, and that's kind of the impetus for a lot of these laws is that the victims are particularly vulnerable. That's part of the reason they're selected, targeted.
What happens when the perpetrator of a hate crime against somebody because of their housing status is perpetrated by an official, some sort, an elected official, municipal official?
Well, an essential element of a hate crime in Vermont is there has to be a criminal act. So you have to be able to arrest somebody for a crime, and then the motivation is secondary. So if you had a town clerk who assaulted someone because they were homeless, they'd be chargeable with assault, and if there was evidence that it was motivated. A few years ago, you clarified the standard so it doesn't have to be the only motive. It could be, there could be mixed motives. And that's often, most hate crimes are more than one motive. It's like, it's the homeless guy plus I wanted that thing that he has, right? There's 2 motives. People rarely act for a single motive. That's certainly true with my kids. So the idea is that you have to have a criminal act. And that's true under federal law too. So there are laws like about interference with housing at the federal level. It's a criminal act, but you have to have threats of violence or threats of violence. And those threats have to be criminal threats. So you have to have an independent crime. So if you're talking about discrimination by a public official, that's not going to be under the hate crime law.
Yeah, but I'm talking about let's say there's an unhoused person who lives in an encampment or stays in an encampment and is arrested by the police, regardless of why they're arrested by the police. And then police come and destroy the encampment. Would that be a crime?
It sort of depends on how the police officer acted. If a police officer just randomly arrests somebody because of the way they look, for example,
So the
That could be a criminal
Okay,
act.
I got
It could be a criminal act. In some other jurisdictions where people are grabbed by the police, they drive them around the neighborhood saying, you're gonna tell me where the guns are, or we're gonna find weed in your backpack or worse, that's kidnapping. So that's a crime
Yeah.
if you have no reason to do that. Whether in a given case the officer has a legal justification, you can act unreasonably under the Fourth Amendment, which is dealing with arrests without committing a criminal act. You need more for a criminal act, including typically a bad intent before we start locking people up. Typically, criminal law requires that you have a bad intent, not that you were negligent or reckless. But if an officer thinks that this person is arrestable for trespassing and they're wrong, the officer or the department might be sued civilly, but they're not likely to go to jail. But if a sheriff in a town just says, we're just going to clear the corners and arrest all these people and drop them off in another county, that could be a criminal act. I mean, theoretically, and certainly using force. There's federal laws, assault under color of authority. Police officers have been prosecuted at the federal level. Our office has prosecuted officers for excessive force. So there can be criminal acts there that are committed by officials. No one's above criminal laws.
Representative Justin Tatum.
Shifting the focus from hate crime, probably the typical concern is or stereotypical concern is a business owner saying, I don't want homeless people hanging out in front of my business, or coming in and nursing a cup of coffee for 4 hours.
I'm from Los Angeles. We call those writers.
Well, then you're supposed to have the laptop open on the table in front of you.
Waiting to hear from your agent.
And I'm just wondering, can you address that a little bit?
Yeah, it's an area that I don't think I really have expertise in because it is the public accommodations law in terms of when employers would do that. So I think Boris probably and other folks probably can speak for experience. So if we receive a call like that, and we do receive those, under the law, really the only thing we can do is we can refer them to BOR and tell them to deal with that. So our office, that's just not an area where I think I'm very knowledgeable, because there are in order to show discrimination in place of public accommodation, the employer may have reasons that are not discriminatory that have to do, like say, disruptive behavior and so forth, and that have nothing to do with stereotyping. But I'm probably not the right person to speak expertly about that aspect of it. I don't want to overstep my area of experience.
Well, I was just gonna ask, would that be like under loitering?
It could be. I mean, in terms of state loitering laws, and this is something that, and I didn't prepare for this today.
Sorry.
No, but I think I'm prepared at least to talk a little bit about some of the provisions that were in the Bill of Rights aspects, where you're talking about people who are soliciting for money, for example.
Right, so if I'm going, I live in South Burlington, I'm on Shelburne Road, and sometimes I've seen people who work in the stores, kind of ask people to move along, and they have, no loitering. Would that be different? I mean, couldn't they just use that if it was?
Well, I think in order, at least under the Public Accommodations Act, you'd have to show it's the person's actual or perceived status. Because sometimes, I think just, using hypotheticals again,
Sure.
with the caveat, this is not my area, but sometimes the concern by employers that the person is casing the place for shoplifting, right?
Right, no,
That would be a
absolutely.
lawful basis to ask someone to leave the store.
Right, yeah.
But not that, you're wearing a yarmulke or a hijab, or, if there's bad, because of the way you look, this color of your skin. And we refer complaints to people of color who say they're being followed through stores or through shopping malls because by security, even though they're just kids out of school. And again, those are cases we refer typically to the Human Rights Commission.
I've certainly had that experience myself and with family members, so.
I've been hearing it my entire professional career, I'm afraid. The other thing I'd just say about the solicitation, there are First Amendment parameters here that are limits on like panhandling, for example. U.S. Supreme Court has recognized a long time ago that the act of seeking money from somebody, typically the cases the court's taken are not people who are in a housing crisis. They are people who work for charitable organizations, and they're out around on public streets. The Supreme Court deems that activity expressive activity. I work for the United Way. I'm raising money for the Hare Krishnas, whatever it is, that's expressive activity. And so it's subject to free speech analysis. And when the government starts permitting some speech in a public place, but not other speech based on the content of the speech, then we're in a very rigorous area of constitutional protection called strict scrutiny, where you have to show it's really a strong government interest that allows you to select why one speaker can be there for a period of time and not another based upon what the speaker is saying. There is a lower level of scrutiny. There's more room that's afforded cities when you're talking about time, what's called time, place, and manner restrictions. So if you are raising money and you are right in front of the ticket booth at a subway and you're blocking traffic, they can tell you, look, go do it up at, and in fact, New York City has an ordinance that limits when people can solicit money, whether they're paying, doesn't matter who you are, or what you're soliciting, but people soliciting money in areas of the subway on the grounds that it impedes foot traffic. It could create a safety risk in some circumstances. And so New York says you can't do it here. You can do it before you go downstairs into the subway. That's fine, that's a public sidewalk, but there are certain areas we want to restrict. We see that in Vermont. We also see it in our airports. Courts have upheld, again, the location. The analysis there is, one, is the government singling you out because it disagrees with your message or who you are? And if not, is it truly time, place, and manner? And then three, does the speaker have other alternatives for their speech? So in a city context, you might have limitations on no solicitations, in front of certain areas. But then the park is nearby, and then that's a place where people could or there are other public sidewalks. That's how courts look at it. But it becomes very, without getting into more detail and me being better prepared, but when you start saying, this speech is okay, so you can't sit down on Church Street, for example, and say, homeless vet or whatever. But you can't do that, but someone else could set up a card table and say, vote for Bernie. The court's going to say, well, why is, so two people sitting on Church Street? Why are you picking and choosing the winner, so to speak? Mm-hmm. That's a much more rigorous level of protection. And so it is something that I think as you take more testimony, you may want to hear some other voices talking about the First Amendment parameters besides us. We're happy to chip in too, but there are those dimensions that are in existing case law that you have to legislate with. You can't go around necessarily because it's the Constitution.
And this is the phrase that the board uses is disparate behavior. I believe you can't, again, that's a clear example of someone who's
Disparate treatment?
Yeah, disparate treatment.
Disparate treatment. Yeah, unequal treatment. There can be laws that, under our laws that we enforce, like in employment, there are two types of putting disability aside, because there are affirmative duties to accommodate disabilities that even if you don't have bad will, you're negligent or incompetent, you can still be responsible for someone losing an employment opportunity. But you can have disparate treatment. Disparate just means unequal. I don't know why. Some judge somewhere came up with disparate. I had to learn it in law school. It's really just unequal treatment, and it's an intentional act. I'm going to choose. I want you to be my lead vice president because I think guys are more aggressive than women. Right? That's the stereotype. That's disparate treatment. There's also a different type of discrimination that's been recognized since the early 1970s by the U.S. Supreme Court and then other courts. That's called disparate impact, which is that you have a rule where you can't prove it has a bad intent, but it has an unequal impact on the workers. So the classic examples would be police departments everywhere used to say, if you want to be a patrol officer, you got to be able to bench press 200 pounds. Well, it may not have been intended to exclude women, but it did. So when you have disparate impact, where you have a rule that's neutral on its face, but has a disproportionate impact to screen out employment opportunities for people. It may not necessarily be unlawful, but the employer has a burden to show, I really need this criterion. And in the weight cases, there were many cases where, I was in another state, let's put it that way, recently working on a project and encountering, quote, patrol officers who I'm confident could not, run an 8-minute mile or lift 200 pounds, right? And so then the question becomes, in light of that evidence, how essential is it for you to be able to bench press 200 pounds? And so sometimes that's an intentional screen. There's a history of doing that in the firefighting profession, for example. There were some notorious cases from other parts of the country where there was evidence showing that was the reason, that there was a height requirement and so forth. But if the employer can show a justification that it is really that you need it, that it's and that there's no other way. There's no other way you can do the job, essentially, or very few ways to do the job, then you can justify it. So there is that disparate impact. So there's two ways. Our experience, our very limited experience with people who are in housing crisis, is that they tend to be disparate treatment cases. So it's very similar to dealing with mental illness. There's such a stigma. Mm-hmm. And with disability, back in the days when Congress was looking at disability 4 years after Vermont addressed it, I might add, some of the testimony there was remarkable. They were, and yes, I was around as a lawyer back then in 1991, where, studies and people said they would rather work next to a convicted murderer than someone with a disability or a mental disability. Right, they're just such stigma that can, and that's been our experience in cases dealing with folks in housing crisis. A lot of stigma and stereotypes, and almost like a permission structure to treat them as inferior in a way. And you see that in popular culture, in movies and so forth, television. Mm-hmm. So it is. It's definitely a population that has challenges from many sides, and we would see them with employment too.
Thank you. So I'm actually going back to hate crime stuff, sorry. So it has to be a criminal act or threat of violence. So for example, if someone were shouting racial epithets and calling people of color the N-word and then threatening to hang them from trees, would that be considered hate crime or no?
Could be. So one, if you're shouting in a public place and disturbing the peace, that's a misdemeanor offense for disturbing the peace. So if you are, that's right now. And it depends on where it is and the circumstances. Using racial slurs ordinarily isn't a criminal act in the United States. When you say threatening to hang people from trees, so that's a threat of violence, you have to see what the context was for that to see whether there's a whole area of case law in First Amendment law that's called true threat law, where you have to evaluate the circumstances, not just the words themselves. The first true threat case, just to illustrate how the courts look at it and have looked at it, it was a case that really arose out of the Vietnam War area, where at a public protest of the Vietnam War, one of the speakers, who was later criminally charged with threatening the president, had said as part in the demonstration, where there were people burning draft cards, you remember the stuff, or some reading in history books maybe, that he said if Uncle Sam placed a rifle in his hands, the first person he would put in his gun sights was President Johnson. He was arrested and prosecuted under a federal statute, making it a crime to threaten the president of the United States. U.S. Supreme Court looked at that case, looked at the context, looked at it was a hypothetical, had no access to a gun, it was political speech, and assessed that under those circumstances, that this wasn't really a serious expression of an intent to do harm, that it was political hyperbole. So it is, in the context of, so when you're talking, depends where it is. The words themselves are not going to be enough. Even harmful language, when it's outside of the context of employment in housing, where the language is used to interfere with your legal right to housing, education, or employment. That's a little bit different. We have fewer First Amendment rights in the workplace than we do in the public sphere. So it would very much depend on it. And there have been cases where it's not I'm going to do it, but it might be inciting someone else to do it. That can also be, but you have to show that it's likely and that the danger of someone doing it at my command or behest is imminent. It has to happen imminently. So if you say someday we're going to be rid of all, Shakespeare was right. Let's kill all the lawyers. Let's get rid of all the lawyers. And by the end of this decade, all the lawyers will have been hanging from a tree. That's frightening to me. It is not a true threat or unlawful incitement. So there are certain parameters about that. But when you're talking to somebody directly and you're thinking about hanging them, that would be, I think, a fair case for a true threat.
Especially if it's children?
Yeah, absolutely. When you're looking at true threat, a lot of the law focuses on the intent of the speaker. It's the standard is it's a serious expression of an intent to do harm.
That's okay. Pardon, I didn't mean to cut you off. I'm sorry. I have another question. So let me shift gears. So if a person is experiencing homelessness and they're on the side of the road with a sign and someone goes by and shouts at them, "Get a job, I'm going to shoot you," is that considered a hate crime?
I'm going to shoot you could be. It could be. It depends who the person. It depends, what the context is, but likely that would be a case where not the part about get a job or I hate you.
Well, I'm just saying to make it because that person, the person is a person experiencing homelessness. And so the person driving by was targeting that person and shouting things at them and threatening to kill them while they were standing outside with their sign. So would that, there's no protections for that under this, would that be considered, and would that person then be a protected class, and that could be considered something? I'm just trying to.
A threat to kill someone, that's a serious threat to kill someone, because those same words could be said in a play production, for example. So merely uttering the words, divorced the context, doesn't necessarily mean it's a threat, but the context you provide, threatening to kill someone where that person, a reasonable person, would think that they were in danger, that's a crime. That's a felony in Vermont. That's a criminal threat. If it's because of who the person is, so if they made that threat a person of color, a prosecutor can seek an enhancement and say, criminal threat is a 2-year misdemeanor, it would be bumped up to a felony because of the motivation that's behind it. The idea, part of the justification for the enhanced penalty, and I feel like I'm telling you everything, you already know this, but let me just say it for the home audience or whatever. Is that part of the reason, and this got litigated in Supreme Court because there were folks who said you're punishing thought if you enhance the penalty. And the Supreme Court said, no. Hate crimes are different because they have a multiplier effect. It's not just the person who's targeted, but it's all the people who identify with that person who are targeted. So you have a hate crime against Asians. We saw this in the pandemic, right? There were hate crimes that were perpetrated against Asians that sent shockwaves across the whole country. We didn't have cases in Vermont, but I can guarantee you there were people in Asia who were terrified when they would read about another hate crime in San Francisco where people were saying, you brought the virus over here, right? So there's that multiplier effect that can happen. So it's a particularly, vicious type of crime, and that's what justifies the enhanced punishment. The other reason for the enhanced punishment is that some hate crimes, that if they aren't viewed as being subject to a higher sanction, can undermine confidence in government. It's just like, oh, that was just a simple misdemeanor, so the government doesn't really take it seriously. That's one other justification. Another is that some acts where the government doesn't have what looks like a very strong sanction, that can prompt vigilantism from members of the public. We're going to take the law into our own hands because this person, look, they were arrested and they got a court date and they're walking around. We're going to take the law in our own hands, but clearly the government doesn't take it seriously. So it's those levels of justification that have been articulated as a reason for tacking on that penalty. But we always lead with the multiplier effect. That's very real. I mean, that's the area we work in all the time, and that's very real. And what happens, again, on a different coast affects the targeted community, sometimes worldwide.
Representative Lau. You're all set. Representative Lau.
Yeah, I just wanted to just see like how this bill is going to impact and help people, if what is covered and what is not covered. Will they be a protected class, and what protections would that offer them? Is what I was alluding to, so thank you.
Now, when you talk about bench pressing 200 pounds and running the 8 mile, the mile in 8 minutes wasn't a big deal when I was growing up. But when I applied for a state trooper, I wasn't 6 feet.
Oh.
So I wasn't allowed, so I was considered a pipsqueak, so.
Yeah.
But to get to your hate crime, now what happened in Florida, when they took all the refugees and then put them on Martha's Vineyard to get rid of them because they're homeless and so forth and so forth, would that be considered a hate crime?
As far as I know, when people were transported, they were transported with their consent. So that I think they were offered the opportunity to be deported to their country, or in cars, they could be subject unlawful entry. If they were caught entering, it is a misdemeanor. If you just can't prove your documentation, you can't be arrested for that. So, but if you certainly grab someone against their will and transported them, there's any number of crimes, including kidnapping. But I don't think these were kidnapping cases. So that's what I think is involved in those cases. I'm not familiar with the details of those cases, but certainly if someone were picked up off the road here and transported to, to New Hampshire, we'd be looking at a kidnapping charge for sure. So, and if they were motivated by bias because of their perceived or known national origin, that would be subject to hate crime and it's really, significantly more penalties. So, yeah.
All right. Thank you so much.
This was.
Thank you.
Thank you so much.
Yeah, it just clogged up a few areas in my brain.
Certainly did.
But no, it's very helpful. It just gives us, I really wanted us to have an understanding of, really like everything else that we do, there's nothing that's simple about any of this, but, to say that there may, as Boris said, that there may not be an increase in cases or anything else like that, it's not a question of putting a number on who it affects or how it affects them. It's the broader unit that rather than the number of cases, I think is what's important here, but also understanding that, as you just spent the last really 15 minutes of just like how it depends, what the context are and where the rule of law for what the AG's office is allowed to not even adjudicate, right? It's just
enforce and investigate.
Yeah.
So I think the other aspect that maybe, I apologize for maybe not highlighting this earlier, our experience when you have broadened the scope of the laws is that our experience, or certainly the judgments that we make based on the case number or the cases coming in the door, is that sometimes you do have an initial bump, but then the cases start going out and employers are educated. They may not be aware of this. We saw this, for example, a number of years ago in this very committee. We fought very hard to persuade the legislature to expressly make clear that if a woman was having a healthy pregnancy, so she wasn't disabled, and needed some accommodation for the pregnancy, that could be restroom periods and things like that. Getting a chair if it's not essential that you stand, those sorts of simple accommodations, not carrying the 5-gallon soup bucket that one witness testified about. When employers know that duty exists, and we go out and we do trainings, and sometimes when we take an investigation, the law firms that represent them are like, hey, sometimes we get out-of-state law firms. We have to educate them as well. For multi-state employers, hey, Vermont requires an accommodation. It's not just acting in a mean way. If you just are disregarding that because you're under the mistaken impression it only applies to maybe high-risk pregnancies, which might be a disability. Well, Vermont is different. And so we try to create that culture of compliance, and it gets worked into, blushing and practically I'm sitting in front of the human resources professional. They're the ones responsible principally for that culture of compliance for education. So we've experienced that several times when there have been changes to the law. Pregnancy accommodation was one, crime victim status was another. Once employers knew that that was there and that they couldn't turn away folks because of an assumption that an abuser or somebody was going to come to the workplace, or someone had a court dates, right? And this is disruptive because now I have to find somebody else. And the law says you have to flex with them on their court dates because there's a public interest in having people testify in court, and hold people accountable for criminal acts. We have obviously a strong interest in that as a state. So once people learn that, then there isn't an issue. Crime victims in particular, when you gave them job protected leave to go to court, the speculation kind of out on the street among employers was that we're going to get a lot of bogus claims. We didn't encounter any of those, and I just don't hear them. People don't. That's something that people are make stuff up. They make something else up. They don't say I have a court date. It's easy to get caught. Much easier to say my back hurts if you're going to make something up, right? or something like that. So I don't. I can't explain what people do, or why they do everything. But so sometimes that there are like worries things could be a stampede. But our assessment, I think, squares with the HRCs. We don't think this would be. We hope we would see some cases at the beginning so people know they have access to justice, but hopefully that there'll be, because it gets around when someone's under AG investigation. Where it gets around, like when I speak at conferences, we have a colleague of mine is going to talk at an HR conference. It's like they're like, oh, so you're Emily Adams. I see your names on the welcome to the investigation letter, and I get the same treatment. One attorney, because everybody in the room seemed to know the name Julio Thompson. It's a unique name, right? And people said, well, we never see Julio. And someone said, if you do see Julio in an investigation, it's not going well for you. So
I thought Julio Thompson was the same as Jenny Crocker. It's just
right. So anyways, I do think that, and go back to those HR professionals, they'll be very much part of whatever you pass. And that's not only for employees. If you limit it to public accommodations, they still have to train their employees how to deal with customers and people who come onto their premises. So that's where a lot of the work is gonna be there. And we always get calls. We often get calls from HR professionals who are seeking that technical assistance. What is your enforcement position on someone who's been, who's unable to provide an address, or we can't reach this person, right, because they don't have an address. Well, we might offer not advice to them, but saying, availability of someone, communication might be an essential function of your employment. That doesn't sound discriminatory to us. So regardless of what the call is, they turn off their phone when they go home. So I guess I'll just leave it there.
Thank you so much for making the time to come back and finish.
Thank you.
If we have further questions, then we will be in touch.
Let us know.
This was very helpful.
And they were great questions, so I appreciate the interaction. Yeah.
We have a responsibility to our educations to have a problem-solving mindset. All right, committee, let's finish up for the morning and we'll see you on the floor. We are going to, we're back in here 10 minutes after the floor. It should be a very short floor. So we're back in here to start getting a walkthrough on S100, which is still warm in my hands from.
You got it?
Ron got it at some point.
Is it online?
Yeah.
Thank you, Ron.
And it's not the red lined one, so
Okay.
it's legible.